Good morning. This is the time and place for the zoning hearing officer meeting of May 25th, 2011. My name is Brad Collin, and I will be conducting the hearing as the hearing officer. We have one case scheduled for today, and the relevant exhibits are posted on the panel located directly behind me. We also have an aerial photograph that's up on the screen for anyone that may be interested. If you wish to speak, please write your name and address on one of the speaker forms which have been provided by the front door and submit it to our planning assistant. I'd also like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded on tape as part of the public record. Notification of this hearing was accomplished by the use of public notices which were mailed to property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper. The hearing will proceed as follows. I'll read the description of the application and request. I will go through the comments received or letters of communications from interested parties. The case planner will make a brief presentation of the case, give analysis, and make a recommendation. Then the applicant will be asked to come forward, stating both name and address. Will be asked to present a case within a 15-minute time limit. Others in support of or in opposition to the application and interested parties will be asked to come forward to speak, again clearly stating both name and address within a 3-minute time limit. Lastly, the applicant will be given the opportunity to make closing comments if desired in response to any testimonies given by the preceding speakers, and that will be with a 5-minute time limit. The hearing will then be closed, and I will briefly go through the proposed description. This is a standards variance to provide 9 parking spaces where 16 are required for uses permitted in the C3 commercial service zone that will not exceed 4 parking spaces per 1,000 square feet of floor area, and the subject application is located at 240 South Glendale Avenue, described as Lot 18, Block 3, in the Glendale Orange Grove tract. We have received no letters or emails in either opposition or a favor of the project. We have 4 comments received from the various departments in the city. The first is from traffic and the transportation section. It had a comment that on-street parking is in great demand on Glendale Avenue and Orange Grove Avenue. The second comment was received from the Building and Safety Division, which had standard comments for obtaining building permits, access to inspect the property, and providing handicap parking and access to the building. The third comment received was from the fire engineering section, which is requiring fire sprinklers may be required and identify the use and location of the loading door. And the last comment received was from Glendale Water and Power Department. The water section commented about standard potable water, including cost for water and fire service, flows and connections, and water quality, including backflow prevention devices. And the Glendale Water and Power Electric section had no conflicts with the project. Other city departments had no comments regarding the specific project. At this point, we will ask Mr. Baxter to give us a brief presentation on the project. Baxter?
Yes. It's at 240 South Glendale Avenue. It's a standards variance to provide 9 parking spaces where 16 are required for uses that do not exceed 4 parking spaces per 1,000. The existing building, which you can see on the wall behind you, is just under 4,000 square feet. It was constructed in 1947. At the time, there were no designated parking spaces. There was a variance to changed the use to a manufacturing use. They manufactured church pews, and that was in 1957. And that use continued for over 50 years. And in that variance, there was a notation that you must keep the parking that you have in the front, but there was not a designated number stated in the variance, because at that time there was no zoning code requirement for parking in Glendale for any use. So this operation continued as such all these years, and without a specific parking requirement. Now, the surrounding uses are in the C3 zone as well, and they're retail, office, commercial. There's some restaurant, there's a car wash, uses that would be allowed in that zone. So this particular one is a use that's not allowed in the zone until they ended just a little while ago, and they lost their right to reuse it as that, because they weren't going to replace the the pew manufacturing again with the new owner. So right now it's just a vacant building, and there is no current. So the request is to basically get the project back on equal footing with its neighbors in the C3 zone, and to have the types of uses that do not exceed the 4 per thousand. So that would mean 3 per thousand would be okay. Anything less than 4 per thousand. So what that does exclude would be uses, anything exceeding, and for example, you have medical offices exceed, fast food or full-service restaurants, that exceeds, banquet halls exceed, gymnasiums, taverns, nightclubs, private schools, all those exceed the 4 per thousand, and that is not part of this request. If those were to be requested, that'd be a whole separate discussion, separate applications. We're talking about retail uses, office-type uses, anything with 4 per thousand or less. And just basically starting again here at this site with that request for those types of uses. And that would place them on equal footing with their neighbors. Now, the surrounding uses are all commercial uses. They're all in the C3 zone, all around the property, as noted on the zoning map. And the staff in our analysis pretty much summed up the same thing that I was discussing, is that for over 50 years the property's been used. There hasn't been any parking problems at that time, and no designated parking spaces. The applicant is now proposing 9 where 16 are required. Staff feels that if you look at the hardship or the uniqueness of the property, or the health and safety or consistency with the general plan, staff feels that those 4 findings can be made, and we have written a recommendation for an approval with some conditions of approval. I can go into more detail if you want, but that's just a quick overview of the project.
Okay, thank you, Mr. Baxter. This time I'd like to open the public hearing. And the applicant, in this case, is Mr. Mike Maniscalchi. I'd like to come up and give your name and address for the record. Public hearing is now open.
Good morning, Hearing Officer Collins, members of staff. My name is Mike Maniscalchi. I am the applicant here on behalf of the property owner, Eugene Hanline. And I believe my address, is 1111 North Brand Boulevard, Suite 200, Glendale, California, 91202. I think we have a unique situation with the property, and I'll agree with everything that Mr. Baxter said, and I'll add just a few things that I believe are important for the case. When the building was built in 1947, no parking code existed or was required for the building at that time. What that means is the building could have been built lot line to lot line with 4,000 feet. This particular property at that time had the 9 parking spaces that exist today. So the building has existed for many, many years with above standard parking, and the building was made non-compliant when the parking code changed in 1986. If you like, I can just go ahead and read the findings into record if you'd like.
That would be great.
Okay, great. So I'll read the finding, and then I'll give you, I'll read the finding itself, and then give you our finding of fact. How will the strict application of the provisions of any such ordinance noted above result in practical difficulties or unnecessary hardships related to the property inconsistent with the general purpose and intent of the ordinance? Our finding is the strict application of the provisions of any such ordinance result in practical difficulty or unnecessary hardships inconsistent with the general purpose and intent of the ordinance, in that the approval of the use variance back in 1955 by the City of Glendale was written so specifically that no other uses are in conformity of code, thus rendering the property useless without a subsequent parking variance. The building had above-standard parking for the C3 zone when it was built, but now requires a parking variance to be utilized under current code. Finding B. There are exceptional circumstances or conditions that apply to the property involved or to the intended use or development of the property that does not apply generally to other properties in the same zone or neighborhood, in that the property had been occupied with a legal nonconforming manufacturing use with above standard parking for that use at the time of the granting of the variance. No other properties in the area have had a use variance with such restrictions that is only legal for that one use. The change in parking codes coupled with the 1955 variance creates an exceptional circumstance in denying the property owner the use and the reuse of this property. So when the variance was written back in 1955, it essentially said, we're going to allow you to do church pew manufacturing and no other use from this point forward. So this property owner is stuck with a building he can't use unless we're granted this parking variance, which would extinguish the previous variance and allow the property to be used from this point forward. Finding C. The granting of the variance will not be detrimental to the public welfare, in that the property provides 9 parking spaces, which exceeds the use that has occupied the property for the past 50 years. The property is currently zoned for office and retail uses. The requested variance will limit the uses to 16 parking spaces or less, which will have no negative impact on the neighboring properties or businesses. Finding D, and fourth finding. The granting of the variance will be keeping with the objectives of the ordinance, in that the objective of the ordinance is to allow this property owner to utilize his property under the same set of standards that other properties in the area currently have. The previous use was restricted because of the way the variance language was drafted, rendering the property unusable for anyone else unless a new variance is granted to accommodate for the change in the parking code. In closing, I would only say that we've been working together with staff for nearly 12 months now to try to get this property to the point where it's at least legal and usable, and we've tried to comply with everything that is required of us under the code. So I would certainly appreciate staff's consideration in moving forward and granting the variance on this property.
Okay.
Thank you.
Thank you.
And I have just a couple of quick questions. I heard the comments from staff specifically relating to fire. Did fire say that sprinklers were going to be immediately mandatory, or they may be required?
May be required.
Based on the improvements that are done to the building?
Right. It was
okay.
a may be required.
Great. Thanks very much.
Okay, I have actually a couple questions for you real
Sure.
quick. Chris mentioned, Mr. Baxter mentioned that the property is surrounded by C3 zone and uses, but I noticed from the photos it appears that there's a roll-up door or something at the back. Is that proposing to remain? Is it openable? Is it?
No. No, I think at one point, maybe in the past 50 years, there may have been a loading door in the back of the property, but it is actually filled with concrete block. And there's a neighboring property owner that their property line comes right up to the back of the property. So for us to have any access at any point in the future would require an easement with the neighboring property owner. And honestly, I don't see that occurring.
So that's not an openable door or anything like that?
Their parking exists right behind our building.
Right, I see that.
Yeah.
Okay, second question. Are there any proposed changes to the facade of the building?
I would
this
venture
time?
to say, based on the way it looks currently, I would say it's inevitable. I think somebody, any person that buys the building is probably going to come in and want to do a cosmetic rehab of some type and potentially eliminate that loading door in the front and probably put in some type of a glass entry door,
Storefront.
would be my guess. That everybody that's looked at the building up to this point has mentioned just that.
Okay. And then my third question is, did you have any thoughts as to where a potential trash and recycling location would be placed in the parking lot?
No, and it's my understanding that most of the people are keeping the receptacles either inside the building or would be building something in the front of the building somewhere. I'm not sure. Hasn't been mentioned up to this point.
Okay. Thank you.
Thanks.
Next, we have Rubik Thorosian. Please state your name and address for the record, please.
Good morning, hearing officer. Good morning, gentlemen. My name is Rubik Thorosian. My address is 1442 Alameda Avenue, Glendale 91201. I am a resident of Glendale since 1979. I've worked in Glendale since early 80s. I am definitely in favor of this project, and by hearing the staff's comment and what Mr. Mike Maniscalchi, who I might add, he won't stand behind this approval of this variance if there was any doubts in his mind. He's a professional that worked in this city for years and years. His name is all over town. He's a true professional. I must have driven by this property thousands of times since moving into Glendale. I know at least half a dozen people that own businesses within half a mile radius of this property. And by just looking at it, I'm not an expert. I don't know anything about the parking requirements. A variance was given, as I heard, since 1955. It is a good building. It looks good. There's a lot of empty spot in the front of the building, and by just looking at the pictures, I mean, it looks like there's sufficient parking there. I wasn't supposed to speak today. I just came to see and hear some comments. But when I saw Mr. Mike Maniscalchi, I said, definitely, if I can speak, I wish other people that I know, they would have known that they can come and support the project, because everyone always says positive things, and there's a lot of people that if they would have known, they could have come and supported this project. So what I'm just trying to say is, it's not me. There's a lot of people that definitely support this variance, and hopefully it would pass.
Okay.
Thank you.
Thank you very much. Mr. Maniscalchi, did you have any follow-up comments or questions? Or
I don't, sir, and I appreciate the consideration. Thank
all
you.
right, thank you. At this point, I'm going to close the public hearing. I have a question of staff. Mr. Baxter, could you briefly go through the proposed conditions of approval?
Yes. That's right. Sorry. Go ahead and tell them I got it on. That number 5, that the subsequent land uses following the first tenant shall be required to comply with the change of provisions. They have to follow one at Chapter 30.32. So if you're going to change of use for anything after the first tenant, you just follow the regular code requirements. Number 6, that any expansion or modification facility inconsistent with this grant may require another hearing. Number 7 and number 8, 9, and 10 are all standard ones that we have for keeping the place clean and orderly, the site. That they provide adequate solid waste containers, things like that. No outdoor storage, and the signs comply with the sign ordinance. Those are standard. Really ones that are different are going to be 4 and 5, which state about the parking. First tenant, and then after that, the applicant must follow all the rules and regulations of the zoning code. It puts them back into the system. So the first tenant is allowed to get in, start their operation, and subsequent to that first tenant, everything else is operated as if it's like any other business.
Okay. Thank you very much.
I was going to say one thing. I don't think there was any plans or documents that ever showed there being 9 parking spaces before this plan. So there's room, obviously, but I don't think we ever saw anything. No other site plan that I ever saw.
Okay. All right. Thank you. I think I'd like to add a condition that requires that a landscape plan be provided and prepared by a person licensed in the state of California to prepare such a plan. And is the applicant okay with the conditions that were? Sure.
I believe the property owner will be okay with the conditions. I just need to understand a couple of them a little bit more if I could. So on items 4 and 5 regarding the parking and or change in use, that means if we have a retail tenant come in initially, we can then go retail to retail to retail. And what you're saying is if we have an office use come in initially, if we wanted to go to retail after that, we would have to file for a formal change in use. Is that correct?
You would probably do the parking reduction at that time.
Okay, so we would then apply for a parking reduction permit. Okay, so okay,
that would be the thing that we would look at.
Okay. The property, although no plan existed, the property was previously striped for 11 spaces. And as we went through our plan, including landscaping, which is indicated on that plan by a licensed architect, we then lost 2 spaces with our landscaping in the front of the property, which is required under current code,
right,
as well as the percentage of landscaping that is now required under code. We then lost another space, which is fine. I mean, I think the property is going to exist just fine from this point forward. So
okay.
I'm clear on change in use. I'm clear on uses after the previous use, and we've covered the previous striping and the lands. Are you comfortable with the landscaping answer that I provided? I mean, obviously, from this point forward, we'll have, if there are improvements to the property, we would have a landscaping plan. I know the plan that we provided has landscaping under current code, not old code.
Right, and with that, I'm recommending, or I guess conditioning, that a landscape plan be provided, mainly for the reason that the city requires drought-tolerant plants, and be able for us to have the opportunity
Okay,
to review, or staff to review, what's being proposed to make sure that it complies with those regulations.
Okay, and when would we be required to provide that plan? When we do improvements?
Well, I assume you're going to be upgrading the parking lot per plan, correct?
Yeah.
Sometime in the
Yeah,
near future.
correct.
Prior to doing that, you'd be submitting in a parking plan. With that parking plan, you would also submit in the landscaping plan.
Okay. Fair enough. Okay, thank you. Appreciate it.
All right, based off the testimony received and findings outlined by staff and the comments received from the other departments and not receiving any letters or emails or comments from anyone else in the neighborhood, I'm going to recommend approval of the subject variance, subject to the conditions that were outlined today with the addition of the requirement for the landscaping plan. And the decision will be prepared in writing. There's 15 days to appeal the subject decision, and the date of the 15 days will be based off the date of the decision letter. And appeal forms can be picked up if necessary or desired over in the Permit Service Center, room 101, between the hours of 7 and 3. And that concludes today's hearing. I'd like to thank everybody for coming. And that's it. Thank you all.